Okay, this is the 100-120 speed level. This is from our admonitions, motions, and stipulations book, and this is an admonition. For the record, I am going to ask you some questions about the accident and about the injuries of you and your family. Everything that is being said here will be taken down by the court reporter and put into a booklet, which we call your deposition. Sometime in the future, you will have an opportunity to read the booklet and make any changes that you might want to make. But if you do make corrections and this goes to trial, whoever is trying the case can comment on the corrections and ask you why you made these corrections. So it is best to give your best answer here so you will not have to make any changes. Now, if I ask you a question that you do not understand, let me know, and I will rephrase the question because we do not want you to answer questions that you do not understand. So will you let us know if you cannot understand a question? Please speak up so the reporter can hear you, because she has to accurately take down what you are saying. Do not nod your head. Answer out loud. Is there any reason why you are not physically up to having your deposition taken today? Then I will proceed with your deposition and then take the deposition of your daughter. Have you ever been deposed before? All right, this is a motion in limine. That was about 110, 120. Okay, for the record, the plaintiff requests through her attorneys that this court preclude evidence of the photographs of the vehicles involved in the subject accident because expert testimony is required to correlate the property damage and the plaintiff's alleged injuries. The plaintiff states as follows: this is a personal injury case involving an auto accident. Expert testimony is required. The plaintiff respectfully requests that this honorable court instruct all parties, counsel, and witnesses expected to testify that no person is to refer to, interrogate, or attempt to convey or suggest to the judge directly or indirectly any of the following: the amount of force between the two vehicles, the speed of the striking vehicle, the amount of damage or lack thereof to either vehicle, any correlation between the force of the impact and the plaintiff's injuries, and to preclude from introducing any photographs of either vehicle at the trial of this matter. This motion in limine to exclude testimony regarding the property damage to the vehicles has been sent to all parties concerned with the case. Thank you. Okay, this is a stipulation. For the record, I propose to enter into the stipulation under the now existing provision of the code concerning disposition of the depositions. In summary, it is my understanding that the court reporter would retain an original copy of the transcript and that you would be notified of its availability. You would have an opportunity to come in, review, and correct it if you so choose, and that if you failed to do that, then an unsigned copy would be deemed to be your testimony that you agree with. In any event, the original copy of the transcript of this deposition will be provided to Mr. Sparks 30 days after its availability. I further stipulate, and that would be that at this time, I have done no cross-examination of the witnesses, and because of time pressures, I believe counsel and I have an agreement that I would reserve my right at a later date to take up this deposition again for purposes of cross-examination. We will also stipulate for the record that all of the exhibits and the original will be returned to the witness after the court reporter has had an opportunity, first of all, to make an original of Exhibit A, an actual print, I mean. Copies of Exhibit B through F can be attached to the original depositions as originals. We can handle everything else according to code. I will give you my card, and if something else comes to mind about what was said here today, contact me. This will be some congressional material for the record. Market economies require discipline. Cutting inflation helps families struggling to become members of the new Russian middle class, so they need not fear the future. Continuing your country's recent record of more realistic budgets is vital to achieving long-term economic stability. I say this from experience. From the beginning of my administration, I have pursued these goals because even though they require some sacrifices in the short term, they promise lasting economic growth that will benefit all of our people and yours as well. The transition to a more honest and open economy requires time. New problems will appear as your economy gains ground. But in the midst of the pain, I would urge you also to see the promise. Countries that were in economic ruin at the end of World War II today rank among the world's most dynamic nations because they have made a market economy and democracy work. Finally, Russia's success at political and economic reform at home requires an approach to the world that reinforces your progress and enhances your security. Russia and the United States must work together in this regard. We must work for our common security. More than anything else, that is what my meeting with President Yeltsin today was all about, and we made progress in many areas. I would like to report them to you. First, Russia agreed to implement its Partnership for Peace with NATO, and I agreed now to press NATO to begin talks on a special relationship with Russia. The United States has made it clear that we favor a strong continuing NATO and that any admission of new members be based on the principles we have articulated along with our partners. It must be gradual and deliberate and open and consistent with the security interests of all of our partners for peace. My goal since I became president has been to use the fact that the Cold War is over to unify Europe for the first time in its history, and that is what we must all be working for. President Yeltsin's decision to join the Partnership for Peace will support that move toward security and unity. Second, the United States strongly believes that there should be no future nuclear cooperation with Iran. We believe that is in Russia's interest. Today, President Yeltsin said that Russia would not sell enrichment technology or training to Iran because that could clearly be used to develop a nuclear capacity. And that should be more important to you than to us because you are closer to Iran than we are. I gave President Yeltsin some intelligence that the United States government has that we believe supports the proposition that no nuclear cooperation in the future, not even the light water reactors, should proceed. On the outstanding issues of arms sales to Iran, we reached an agreement with Russia, which will now permit Russia to be one of the founding members of an agreement among nations to limit the sales of all dangerous weapons around the world in ways that will increase your security and ours. Next, we agreed to immediately work to see if we could get our prospective parliamentary bodies to ratify the START II treaty this year so that we could continue to reduce our nuclear arsenals. And after START II is ratified, we will consider further reductions in the nuclear arsenals of the United States and Russia to make your future safer. We also agreed to a statement of principles on one of the most difficult issues in our security relationship, how we define so-called theater missile defenses in the context of our anti-ballistic missile treaty. Okay, this is some jury charge material for the record. During the course of the trial, members of the jury, it has been my duty to rule on a number of questions of law. These include objections to the admissibility of evidence. This also includes objections to the form of the questions and other legal matters. You should not draw any conclusions from these rulings, either as to the merits of the case or as to my position with regard to any witness, party to the case, or the actual case itself. Members of the jury, it is the duty of the lawyers to make objections when they believe an objection is proper. You should not be influenced by the fact that these objections were made. You must disregard any evidence which I have ordered stricken from the record. Members of the jury, you are the sole judges as to whether or not the testimony should be believed. When making that decision, you may apply your own good common sense and your everyday life experiences. In determining whether or not a witness should be believed, you should carefully judge all of the testimony and all of the evidence and the circumstances surrounding each witness and what they have testified to. You should not conclude from my conduct or any of my words that I favor one party as opposed to another. You should not conclude that I believe or disbelieve the testimony of any witness. You are the sole judges of the believability of each witness and the weight of the evidence. You must not be influenced in any way by my conduct during the course of the trial. The party who asserts the claim has the burden of proving it by what we call the preponderance of the evidence. In order to prove something by a preponderance of the evidence, a party must prove that it is more likely true than not true. In other words, a preponderance of the evidence means such evidence which, when considered and compared with the evidence that is opposed to it, has a more convincing force and produces in your minds a general belief that it is more likely true than not true. So that defines for you the preponderance of the evidence. In determining whether or not a party has met the burden of proof, you should consider the quality of all the evidence, regardless of who called the witness or who introduced the exhibit, and regardless of the number of witnesses which one party or the other may have produced. If you believe that the evidence is evenly balanced on any particular issue, then your finding on that issue must be against the party who has the burden of proving it. Members of the jury, in order to reach a verdict in this case, each of you must agree upon it. Your verdict must be unanimous. Thank you.